Welcome to Immigration Uncovered, the DocketWise video podcast where we dive deep into the dynamic world of immigration law with the latest developments in law and policy, cutting-edge practice management strategies, and the transformative impact of legal technology. I'm James Pittman, and today I'm joined by Jonathan Wasden. And Jonathan is one of the plaintiffs' attorneys in the recently filed case of Moody et al. Versus Mayorkas, which is a federal lawsuit that seeks to block USCIS from implementing the filing increases that are in fact going into effect today. Jonathan, thank you for joining me today.
Thank you for having me. It's good to be with you.
Okay, and Jonathan, you are the founder of Wasden Immigration Litigation. Let me ask you first, what prompted the decision to file the lawsuit against USCIS regarding the filing fee increases?
So, obviously, the clients are the ones that drive the train on that. Okay. And to understand what motivated them, you really kind of got to take a step back and look at some institutional biases within USCIS. Okay. I worked there for a while, so I have a bit of an insight into that. There's two visa categories that they really dislike, the H-1B and the EB-5. And so you see the brunt of all these fees attacking those two visa categories.
Why do you think they dislike those categories?
Well, I think there is a couple of reasons. One is, there's always the fear of latent racism or something like that, but I think you have all these government employees. None of them have technical degrees. None of them have a background in IT. Most of them can't map themselves to their own printer. And they're adjudicating all of these very high-end H-1Bs and EB-5s. And they're seeing all these people make a lot of money. And I think that might be possibly one of the explanations, is that they're a little bit miffed that they're not making the money that immigrants are making.
Wow. Okay. That's it. I've never heard it. I've never heard anyone put it quite so bluntly. If you think envy plays a role.
Yeah. There's also just an amazing amount of arrogance in USCIS these days. And it's part of their transition from an adjudicating agency to trying to be a law enforcement agency, which is one of the things that we hit on in our lawsuit.
All right. Let's continue. So these two categories, H-1Bs, EB-5s, were particularly hit.
Yeah. So the fees make it very difficult for people like my client, ITserv. ITserv is, the largest trade group representing the small, medium-sized IT companies, and they rely heavily on the H-1B. The large companies, what they call product companies or end clients, rely heavily on the ITserv companies to fill short-term needs and to fill gaps in projects, so they don't have to hire somebody and fire somebody really quick for a short-term project. So they hire the staffing companies. The profit margins aren't great on staffing companies. And so what we see happening is the substantial increase in fees is taking a hit. But for the staffing companies, it's even more exacerbated because they typically are running on an industry standard 6 months contract for an employee. So that employee is going to be moving sometimes every 6 months. And so every time they move that employee, they're having to refile and pay these fees again. So it's conceivable for them to be paying these fees, 4 or 5 times over the 3-year visa. And that just gets really cost prohibitive, when you're spending that much money on one employee. For AIIA, they're the only group that I'm aware of that represents immigrant investors. And when you see the fees that USCIS is trying to soak the immigrant investors with, it's staggering. And it really is going to, I think it's going to actually end up generating maybe less revenue because fewer people are going to, apply for it.
Taking it out of the sweet spot. And that's an issue. That's an issue that all investor visa programs around the world, all golden visa and things like that, have to think about is what is the sweet spot? If your goal is really to raise revenue and you set it too high, people aren't going to be attracted to it.
Yeah, definitely. And I think the agency makes the mistake of thinking everybody who's filing an EB-5 is independently wealthy. A lot of these people, I have a lot of clients that are in this boat, came here on an H-1B, script and saved for a decade, and then they apply for an EB-5 because it's a faster route to a green card. So their entire life savings is wrapped up in that EB-5. And those are the people that really are going to be hit. The less economically, benefited or gifted folks are going to be the ones that are pushed out of the market.
Now, I know in the case of the EB-5s, I was going through the new fee schedule. I mean, it's basically it has increased exponentially. I mean, what is it by factor of?
So depending on the form type we're talking about, it goes up several 100%. It's a lot.
Got here we go. The I-526. It's gone up to $11,160.
Yeah.
What was it previously?
It was I think it was 3,000 something. So it was like almost a 300% increase.
Right. So very, very high. Let's talk about the lawsuit. So let's talk about what you're alleging in the complaint. So first of all, where did you file? I think you filed in the Federal District of Colorado.
Yeah, so I like the 10th Circuit because of its libertarian Gorsuch style philosophy. Okay. And so we figured in the 10th Circuit, we have a great chance of getting the right type of judge, and we can appeal it to the 10th Circuit Court of Appeals, who I think is probably going to be one of the more favorable courts to our arguments that is out there. So we have 3 different counts in the case.
Okay.
So the first count is whether or not the Reform and Integrity Act required USCIS to conduct a performance-based fee study prior to raising fees on EB-5s. And it seems pretty clear that that was Congress's intent. Yeah, they put all kinds of parameters for how this study was supposed to generate fees and demanded that it be done by a certain deadline, which I believe is March 1st. They blew past that deadline without any concern and raised fees that were not based on performance metrics. And that's exactly what Congress told them not to do. The second ground is challenging more fiscal law issues. So it's a little different. It's outside of the typical immigration and APA context. But what we're alleging is, that every fee category that has been created by statute. There's never been a fee category created by regulation. And the way we see the law, fee categories have to be created by statute, not by the agency fiat. And so that's one of the issues in the asylum fee. The other fiscal law issue is the agency was told by Congress not to spend money on certain activities, one of which was investigation. What we see going on right now is the number of people working in USCIS's FD&S, that's their basically investigative police force. It has gone from, I want to say it was around 750 in 2018 to well over 2,000 now and climbing. And so they're diverting all this money away from adjudicators, putting it into these investigators, and meanwhile, processing times are abysmal. So our read of the law is that Congress did not want them doing that because they delegated that authority exclusively to ICE. So ICE should be doing the investigating. USCIS should be focused on adjudicating, and they're distracted from their only goal, really.
Could you elaborate on the claim that the final rule was promulgated without appropriate notice and comment?
So in the preamble to the proposed rule, they had a contact info for if you wanted to view the data that the rule was based on, that the fees were based on. And so myself and several other groups, nationally prominent groups, we contacted that number. The number rang. Nobody ever picked up. And this was over the course of a month. And so there was another phone number that was listed in there. So we called that, and it was just some random government employee that had no idea what we were talking about. And so we ended up, having to threaten to get an injunction to get access to this evidence. So we show up at we schedule an appointment with the agency, rather. And we're scheduling the appointment. I said, okay, I'm bringing my expert with me. We're going to take a look at all this data. And they said, oh, no, you can't see the data. You can't see the data that we're basing the rule on. What you can see is we'll give you a description of how the program works, how the computer IT system works, which is not terribly helpful at all when you're trying to figure out if the agency's math is correct. And so because they didn't allow access to the evidence the rule is based on, the argument is that they failed to comply with the APA's requirements.
Now, what specific aspects are being challenged as unlawful or arbitrary?
In an APA case, everything is going to fit into arbitrary and capricious. And the way that the Supreme Court basically distills that down is, did you consider things that you were supposed to consider, or did you consider things you weren't supposed to consider in formulating a rule? And so everything kind of rolls into that arbitrary and capricious once you find congressional intent in agency action that doesn't comply with congressional intent. So, all of the claims in the case basically come down to being arbitrary and capricious because Congress at different points has told them to do things and they're not doing it.
Now, from a legal standpoint, how does the Administrative Procedures Act, the APA, come into play in this case?
So the APA is the handbook that the government has to follow when they're making rules, when they're making decisions. And it has some pretty firm requirements. There's a notice requirement that they have to give you notice of proposed actions. There's the opportunity to review evidence before an action it takes. And then there's the written decision requirement. And if the agency doesn't comply with all these things, if they don't give adequate notice, then it's a violation of the APA. And so for the access to evidence issue, that's definitely what we're really leaning hard on, is the language in the APA that says that they're required to give people access prior to making a final rule.
Now, there's a proposed asylum program fee. What is it? What do they say that it's supposed to do? Who's going to be paying it? Looks like it's falling mostly on the petitioners in employment-based cases.
Yeah, exclusively. It's hitting the goose that laid the golden egg, basically. So the companies that file the most visas are getting hit with the highest fees. So they created the new fee category, and it charges $600 per petition for companies that are larger than 25 and $300 for smaller companies. So, earlier we were talking about how, the IT serve companies are filing a lot of petitions in this 3-year span. The percentage increase is just astronomical that they're now having to face per petition. And over the course of that 3-year span, that asylum fee just really jacks up the cost on the businesses.
Would there have been some sort of an alternative arrangement for trying to defray the costs of the asylum system? Obviously, you don't want to be charging asylum applicants the fee. It's been, applying for asylum has been free for, as long as there's been an I-589. Yeah. Maybe a more broad-based, smaller but more broad-based increase across all the categories would have been better. Or, I don't know. Have you given any thought?
So I think the easiest fix to this problem is for them to follow the structure of the statute, which is they adjudicate, they don't investigate. There's 2,000 people that are getting salaries from the agency and being housed by the agency for doing investigation, which they're not supposed to do. And so if USCIS devoted that money to adjudication, the asylum problem would be gone.
What are the implications of the fees going up this high? It becomes less attractive. We've said that. Anything else?
So one of the hard things about EB-5, and this is why Congress had the AIIA language in it for a performance-based fee study, is that their record keeping and their data collection is abysmal within the EB-5 category. And they don't have any clue of what's going on.
How do you know that, John?
Oh, because it says it in the statute. Yeah, that was one of the things in the legislative history where they were frustrated with USCIS and that they have to create these performance-based metrics, which requires them to collect the data that they have been oblivious to.
Not all in the Reform and Integrity Act?
Yeah. The implications are they don't really know how this is going to impact their overall revenue because they don't really have good numbers. From what I see anecdotally, a really high percentage of EB-5 applicants are people that are not massively wealthy, right? They're the people I was referring to earlier that, scrimped and saved, got together their $500,000 and filed. Those are the people that are going to be priced out of the EB-5 market. And I think that will bring the numbers down quite a bit and also the agency's revenue. So it's conceivable that we could be in a situation where the demand drops for these visas so much, H-1Bs, EB-2s, and EB-5, that we're just going to have to go through another round of fee rules because the revenue is not matching expectations.
So let's talk about the statutory requirements that were in the Reform and Integrity Act, the RIA, that was passed in 2022. Which of those requirements are you alleging have not been met by USCIS?
The fee study. I mean, that's the easiest thing to point to, is they were required to come up with a fee study which set fees based on performance metrics.
In your view, that impacts the legality of the whole final?
Yeah, so they put a firm deadline of March 1st of 2023 on that, and they blew past it. And so they do the rule without going through the fee study process. And Congress was pretty clear in the RIA that they shouldn't be raising fees without connecting those fees to performance-based metrics.
Mm-hmm. Understood. And let's talk about the role of the American Immigrant Investor Alliance in supporting the legal challenge. So they're one of the plaintiffs.
Mm-hmm.
And, how did it arise? They came to you with the idea for the suit or what?
So I've got a long-standing relationship with ITSER. My co-counsel, Matt Galati, has a long-standing relationship with AIIA. And so Matt and I and Jesse, we were just kind of comparing notes on how we wanted to challenge this issue. And we decided it made more sense to have a bigger tent and bring these two groups together so that we could fight for both of their causes.
Got it. Well, there's obviously a lot. When did you start getting ready or make a decision to file the suit?
Later than we would have liked. So yeah, there's always a huge buildup where people takes them a while to make the decision to file suit, and getting the clients through that pre-suit process sometimes takes longer than you'd like. So we got it going probably later than we would have liked. Ideally, we would have got it going so that we could file a preliminary injunction motion and not ask for a TRO like we had to do. And we'd have time to brief that before the rule goes into effect and get a decision from the judge.
Let's talk about that for a second.
Mm-hmm.
So you did file for a TRO, and as of today, that has not been granted. You're still waiting on the decision?
No, Friday evening, the judge ruled. And so when the government opposed the motion, they only focused on irreparable harm. And they said the harm wasn't irreparable because people who pay unlawful fees can go to the federal court of claims and ask for a refund of those fees. And therefore, it's not an irreparable harm. I think it's kind of specious because they're going to have to pay an attorney to get those fees back, and it's going to be irreparable eventually. So that was the only argument that they really made, was irreparable harm. They didn't touch the merits. And so the judge didn't rule on the merits of the case. She didn't opine on, what the likelihood of success on the merits was, and only ruled on irreparable harm. So, going forward, we're going to summary judgment, and we'll be briefing the merits, and the irreparable harm piece will be, out the window, because that's not really relevant to summary judgment.
Now, in order to have requested a preliminary injunction versus a TRO, you would have had to file earlier?
Yeah, so if you do a preliminary injunction, you usually file ideally 3 weeks before the rule goes into effect. The government has, you negotiate a briefing schedule, but usually they'll get, 2 weeks to reply, and then we would get a week to make a reply brief to that. Then the judge makes a decision from there. So it gives the parties and it gives the court more time, which is always better for getting a decision that is what you want. But unfortunately, we were stuck with a TRO where we had to file before the Monday before the rule goes into effect.
Do you think that you would have had a greater likelihood of success with a preliminary injunction?
So I think we would have kept our first judge. So the case was assigned to exactly the type of judge that we were looking for in the 10th Circuit.
Okay.
And he's a senior judge, and I think the compressed timeline just didn't work, for his schedule. And so it got reassigned to a new Biden appointee. I think our arguments would have been probably better received by, an old school Republican, an H.W. Bush Republican that sees the value of employment-based immigration. So, that was probably the worst part of the timing, is that we lost that judge.
Okay, so the entire case has been reassigned.
Yeah.
All right, let me ask you a question, if you don't mind. So aside from the plaintiffs, the Immigrant Investor Alliance and IT-CERT, are there any other organizations or campaigns, helping to defray the cost of the suit?
No, AIIA has a GoFundMe site that they're running for it, but there's really nobody else that's chipping in fees. In fact, the companies that are hit the hardest by this, the very large consulting companies, they aren't, spending a dime on litigation, and I don't think they ever have. So there's really nobody, contributing financially. There's a lot of people that are armchair quarterbacking. There's a lot of people that are chirping on the sidelines, about what should be done or what shouldn't be done, but nobody that's actually paying the bills is engaged in that. And so,
how do you anticipate that the outcome of this case, either way, would impact USCIS and immigration policy moving forward? Like, suppose you win, what do you think lasting impact would that have? And then on the other hand, if you were to lose, aside from the fact that the fees are, the fee increase remains, do you see any other impact?
So it really depends on, if we're successful, it would depend on which one of the counts the judge rules with us on, or, multiple. If we were right on the fiscal law issue, then we would see USCIS become a much trimmer organization, and they would lose the fat of FDNS and devote that money towards adjudication, which would speed things up and would really help everybody. If we win on the fee study rule, the agency will have to be a little bit more accountable, because they're actually going to have to meet some performance-based requirements. And right now, their take in the proposed rule and the final rule is that, Congress said we had to do this, but we don't have to do it. We can keep raising fees indefinitely without ever completing this fee study, and there's no problem with that, which is a pretty bold statement for a federal government agency to say, and basically tell Congress to go pound sand.
Got it. When you go to trial on this, are you expecting to utilize experts, and what type of experts would be useful for in the case?
Yeah, so we are looking at experts. We're getting somebody that has some statistical ability to look at government budgets and analysis. So that's the expert that we tried to take with us to view the evidence back when the rule was still pending.
Yeah.
And ideally, we'll force access to the evidence and be able to take a look at that and then break down and see whether or not USCIS's cost projections make sense and whether or not they add up.
When would you anticipate that this would go to trial? Any thoughts on the timeline?
So I think, very optimistically, we would get the administrative record within a month and a half. We would be filing briefs a month and a half later. And then, court would probably give a decision 4 or 5 months after that. If we get bogged down into access to evidence issues and we have to start briefing whether or not the government has to produce the evidence, then it'll probably drag out a little longer.
Okay, understood. And I mean, how has the suit been received, in the public square? I mean, in terms of the immigration bar, the immigration law community, and the media. I mean, have you, had requests to do other interviews, and what level of awareness are you finding that there is regarding your suit?
So there's pretty good awareness, actually, which is,
Okay.
I guess, not terribly surprising because it's an issue that impacts everybody one way or another.
Right.
The immigration bar is kind of bifurcated, and you have the employment-based and you have the humanitarian side, and they have different clients and they have different motives. And so the employment-based folks are all pretty much in favor of the suit and challenging these fees that are going into effect. The humanitarian side, not so much. The reasoning for it, I don't really get, which is they think that if this current fee rule is rejected by the court, that the Trump era fee rule that was enjoined in the Northern District of California will then automatically spring into effect. I don't see how in the world that would be legally permissible or even something that the agency would consider, because the fundamental problem with that case in the Northern District of California was that the agency created a rule without having an appointed person signing off on the rule.
Rick, can you just give us a little more background of what was that increase? When did that occur and what happened?
Oh, yes. I think that was 2021, so just 2 or 3 years ago. So it was a case filed in the Northern District of California challenging a fee increase from USCIS. Chad Wolf, who was the acting secretary of Homeland Security, had exceeded the amount of time he could be acting. And he was never appointed by Congress or confirmed by Congress.
Right.
And so the agency was being run for a period of time by somebody that actually didn't have any statutory authority to run it. And the court said, you can't do that. When you create a regulation, it has to be approved by somebody with the legal authority to promulgate that regulation. And they didn't have that. And so that's a legal infirmity that's not going away. They can't, hop in a time machine and fix that one. And I just don't see how that rule that was enjoined on those grounds gets automatically triggered into existence.
Apart from that case, are there any other precedents for challenging fee increases from USCIS? Is this something that's, been successful in the past?
There's been surprisingly few fee increases because, the few regulations in general from USCIS. The regulatory process is incredibly stifling. The amount of bureaucracy and wasted time that goes into a new regulation is hard to believe if you've not seen it from the inside. So there haven't been a lot of fee increases. I think 2016 was the most recent one before the 2020. So in recent decade, the government's batting 500 on their fee rules, and we'll see how they do it this at bat.
Okay. How are you feeling, overall about the prospects for the case? I mean, still optimistic even after Friday's decision on the TRO?
really don't see how on the merits they get away from the RIA's performance-based fee requirements. That seems very clear in the statute that they had to do that before jacking up fees. I think that's the most likely issue to win on. Then the question becomes whether or not the court will sever the EB-5 fees out from the rest of the rule.
Or just about that.
Which I don't think they can do, because when you read the rule, what they're basically doing is redistribution of wealth from employment paying for asylum, right? And so the employment people are subsidizing the asylum adjudications. The people that are getting soaked the hardest is EB-5. So if you take out those fee increases, those massive fee increases, there's going to be a massive hole in the budget. And the agency will be strapped and won't have the cash to do its job. So I don't see how they can sever the rule that way.
And how far are you willing to take this? I mean, it certainly sounds like it's something which could be, ending up in the 10th Circuit.
I think if we don't win at the trial court level, the district court level, I really do like the 10th Circuit for, they're very strong libertarian, government accountability, type mentality. It's a very Gorsuch circuit.
Were the 10th Circuit cases that come to mind on other government action that gives you that optimism? I mean, that you want to share?
So there's quite a few actually, and that's a big part of why I grew up in the 10th Circuit, and there's just this very strong sense that the federal government is abusing its power all the time, and they have too much control over things, and they need to back off. And the 10th Circuit cases, especially on environmental law, they really do come in, bring the hammer down on the government more frequently than anybody else, and find the government's abusing its authority and creating some of these rules.
All right. Well, Jonathan, by representing the plaintiffs, you are serving as their legal representative. I mean, in our audience, there may be people listening who will be affected by this fee increase. I mean, there obviously are. What message would you like to convey to individuals and organizations who may be listening to our podcast and who would be affected by the proposed fee increases about your efforts to challenge them?
So I would say what everybody in the immigration space needs to realize is they don't want to be the frog in the boiling pot of water. The old story about the frog gets into the pot of water, it's lukewarm, and you crank the heat up until it's boiling, and the frog never leaves because it just doesn't notice the incremental change.
Right.
That's what's happening. And so everybody's eventually going to get the pinch. So people should be fighting for their rights and engaging long before it gets to the boiling point.
Yeah. Reminds me of, inflation and so forth, and the overall the inflationary climate, similar to that. These little increases, and before you know it, it turns into a large increase. But Jonathan, you mentioned the GoFundMe page. Are there any other ways you want to give us more information about the GoFundMe page, or any other ways that concerned individuals can contribute to supporting your efforts in halting the implementation of the fee increases?
They could reach out directly to Matt Galati or Jesse Bless or myself if they wanted to contribute, or the GoFundMe page. I can get you the link after the show, so you can post the link if you'd like.
Yes, we'll post the link along with the video. All right. Well, so Jonathan, we want to thank you very much for joining us to talk about the suit. It's really, an admirable effort. I wish you success. And again, thanks for joining us on today's episode of Immigration Uncovered, and good luck.
Thank you. It's good to be with you.